going to ask you some questions, and I'm going to try to be as direct as I can when I ask them, okay?
Yes, sir. Good morning.
Good morning. I think when I've talked to you before, I've just asked if you, my questions are going to generally be tailored to, because we got a lot of ground to cover. I'm going to try to ask you questions that call for a yes or no answer. I understand that, you understand that?
I do understand.
Okay. If you have difficulty answering the question yes or no, just say, I can't answer it that way, and then I'll attempt to do a better job of reframing the question, okay?
Yes, sir.
And what I'm going to do is, Mr. Blanco, I put down a copy of the transcript. What I'm going to do is this as well. Can I approach, Your Honor?
Yes.
So I don't have to approach repeatedly. All right. This is a copy of the transcript from the preliminary examination where I already cross-examined you in Oak Park. You remember that proceeding?
Yes, sir.
Okay. Take that, just put it down, face down. If you need it, you'll have it here. This is an entire copy of your investigative file, your report from this case, as I understand it. I'm going to give you that as well. Just, if you need to refresh yourself, if you need to refresh your memory, just let me know, and then you'll have it right there, and we can save a little bit of time, okay?
Absolutely.
All right. You're a state trooper,
That's correct.
and this Michigan State Police has policies, correct?
Yes, sir.
Okay. And those policies are called official orders, are they not?
Some of them are, yes, sir.
And they're assigned numbers, correct?
Some of them are, that's correct.
For example, there could be an order number 1 or order number 5, right?
That's correct.
Order number 87. Have you heard that number before?
Yes, I've heard 87 before.
Have you heard order number 87 before?
Not by number, I couldn't reference it.
Would you agree with me that, let me see if this language, if you've heard this before in your experience, okay? Let me back up 1 second. The Michigan State Police has policies about preserving and collecting evidence, true?
Yes, sir.
The evidence collected has to be collected, cataloged, or indexed, correct?
Correct.
Evidence can be photographed, correct?
It can be.
Okay. And let me ask you, the Michigan State Police has a policy that says certain procedures shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
Yes, sir.
Okay. Your Honor, I don't think there's any objection by the people who have already to the admission of Defense Exhibit A, which is official order Michigan State Police Policy Order number 87. So I would move at this time to have Defense Exhibit A admitted. Unless, it's okay. If I misunderstood the stipulation, that's fine. If I did, then I'll question about it.
I'll stipulate that document. I don't know if it's an official, I don't have personal knowledge that's an official order, but I stipulate for admission of that document, sure.
I don't receive it.
Okay. And there's Defense Exhibit A. Now, you testified that, what policy number, we'll strike that, the Michigan State Police, you haven't produced, and tell me if I'm wrong, an actual written policy that says that in OWI or open intoxicant cases, that you should dump out the contents of the bottle and or not actually catalog or preserve the bottle. Is that true?
You're asking if I've produced a
Yes.
document?
Yes.
I have not produced a document.
Is there such a document?
I am not sure, to be honest.
How did you get the order to process open intoxicants by pouring it out and giving the container back?
Judge, it's my contention that there is no such order.
Well, I'm just saying how.
I
But
understand.
I mean, obviously you don't see an order here, but how did you learn to do that? And who told you to do that?
Because order number 87 says that, and if I could just intercede, Judge, order number 87 says, if you look at the exhibit and you look at page 1 and page 2, it says the following procedures shall be followed in order to ensure that a proper record is maintained of all property. Evidence taken after 1/1/1999 shall be identified by attaching an exhibit label generated by the department's records management system. Non-identified, and there's a sticker, obviously. And then evidence that received, transferred, removed, replaced, or disposed of the property segment shall be updated. Do you want to take a look at that policy to answer whether or not that's what that actually says? Trooper Kaiser?
Should I answer the judge's question
Oh,
first?
do that
or-
and then you can answer mine.
Okay, yes, sir, Your Honor. Not all policies are contained within the official orders. They're general guidelines
Okay,
to operate by. There are local post policies, there are district policies, much the same way different courts of jurisdiction have different policies.
okay,
Not everything is contained in this.
okay.
There are local policies and agreements with prosecutors' offices, et cetera, that supplement these.
Okay.
Let me ask a question about that then, Trooper Kaiser. Let's start with this exhibit and then we'll get to the local agreements that you talked about. The Michigan State Police Policy Number, Order Number 87, says that is take a look at it, it's right next to you if you want.
Yes, sir.
That is the official policy that shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
That is what this official order says, yes.
And it says that property or evidence taken after January 1, 1999 shall be identified by attaching an exhibit label generated by the department's records management system. Is that what that says?
If the property is taken, yes.
Okay. And I thought that you would say that. And then the next section says that evidence that's either received, transferred, removed, replaced, or disposed of. Want to take a look at that? It says that
No.
shall be preserved or collected in some fashion, right?
Yes, sir.
Okay.
I believe you use the word cataloged, which is what my report does. It catalogs that.
We'll get to this. If you can't answer my question, then just let me know and I'll do a better job of rephrasing, okay? You said that you've previously testified, as you have just now to the judge, that it's not our policy to place the bottle into evidence. Have you said that before?
Yes, sir.
Okay, so let me ask you this question. You told the judge that there are some local post policies about open intoxicant cases.
I
Okay.
told him there were local policies. I did not specifically state open intoxicants,
Okay.
but
Well, let's make it specific to the judge's question so we don't mislead the fact finder, okay? Would you share with me what post policy number says that in an open intoxicant case that the bottle should be dumped out and the bottle should not actually be placed into evidence or photographed? Tell me the policy number and I'll FOIA it.
yes, sir. Not all policies have numbers. Some are memos, some are letters of understanding.
Tell me
Not
the memo.
everything has numbers.
Where's what? I just want to know if there's a policy.
Let me get to the point.
Yeah.
Okay, what was the legal state police policy, procedure, order, whatever?
Yes, sir.
That you followed in pouring out and not taking into custody the open intoxicant bottle,
Yes, sir. Since the day I came in the department,
which was,
March 10th, 1996. As I said, I'm in my 15th year.
Right.
From that time forward, we have always disposed of the alcohol at the scene due to storage problems, fermenting, potential explosive situations with higher concentrations of alcohol. We don't store that in our property locker. Also, the sheer volume of the size of alcohol containers and liquids, et cetera, prohibit the prolonged storage of them in our property locker.
well, no one has actually ever been arrested for open intoxicants because you'd have no evidence.
Yes, sir. It's cataloged in our report, and based on our training and experience, obviously, you know what alcohol smells like. I know what alcohol smells like. It's in a manufacturer's bottle claiming it to be alcohol.
True, the judge is asking great questions, so I don't want to interrupt him, but let me.
Oh, that's fine. You know the
They're
area.
good questions, because the importance of the bottle, well, let me back up. The importance to the accused in a case is that he has the right to challenge or contest evidence later on in court. You understand that?
I do understand that.
And that the location of the bottle, for example, is an issue in an open intoxicant case, correct? It can be.
It can be.
In other words, was it in the trunk or was it in the interior passenger compartment of the car, right?
That would be
Okay.
a factor.
One
yes.
way to actually preserve the location of the evidence would be to actually take a photograph of it, where you observed it, true?
That is one way, yes.
Another would be to bring over an eyewitness, for example. Could be some passerby, could even be another backup officer, true?
It could be, sure.
Another could be to actually have, to leave the evidence where you observed it, and when a tow operator comes, have the tow operator inventory the item where you observed it, true?
It is possible, yes.
Okay. In the Michigan State Police policy, order number 87, can we agree that that's the only written policy that you could produce that describes what to do with evidence of a crime? Can we agree with that?
Readily produce, yes.
But do you mean that if we took a break, for example, that you could show up here if the judge instructed you to in the afternoon or the next day with some policy that says you were taught that it's appropriate to dispose of either the contents of a bottle or a bottle itself that could be evidence in a case? Are you saying that you could produce that?
I don't know if I could, sir.
Okay. I'm going to assume until it's produced with the judge's permission that if you can't produce a list or something that says that, then it doesn't exist. Okay?
That's fine, sir.
So, policy number 87. There's no photograph that shows this alleged open bottle of liquor in the interior of the car, correct?
No, sir.
There's no photograph that shows the condition that the bottle was in, whether it was in the interior of the car, whether it was in the trunk, true?
There's no photograph of that. That's correct.
There's no photograph of whether the seal on the bottle was open or broken, correct?
There is no photograph of that.
There's no eyewitness. For example, this other backup officer you mentioned today, who we'll get to, she's not an eyewitness to the location of the bottle, is she?
I don't know.
Okay. Well, you said that she arrived after you'd already done everything. And I want to, is that true?
She arrived after Mr. Jordan was in custody.
Okay. But did you actually make any notations in your report where you said, I showed Trooper Millhouse where this bottle was located to have another witness corroborating that?
I don't believe so.
Would you tell Judge Saunders whether Trooper Millhouse was even mentioned in your report?
Hold on a minute. Mr. Blanco, is the basis of your, you're not going to open intoxicants, you're going strictly on the basis of the fraudulent license?
Multiple, yes, that as well, Judge.
All right.
Because and I'll share with the court, our theory of the case has been known in our, it's my contention, Judge, and it's our contention that there was no open bottle of liquor in the vehicle. And my client, on top of that, we have another witness who will come.
But knowing that the arrest will fall or stand on whether or not the condition of the license, whatever, creates probable cause to arrest them, not anything to do with the
I can go right to the
open
license, and if we're going to move past the open intoxicant issue, I'll go right to the license issue. That's fine.
Too, Judge, I'm fine with that.
That's fine.
Okay, yeah, all right.
Okay. Roll today. So, all right. So
We
let
call
me-
that a sort of a soliloquy,
Yes.
nothing to do with
Yes.
the case.
No,
All right,
no.
go ahead.
You approach the driver's side of the car, right?
Yes,
You ask for identification.
yes,
The driver produces a piece of identification. True?
yes.
The identification was and we'll just, before we get to describing it, let's just talk about its condition. It was an actual, said Michigan on it, right?
Yes,
Said Michigan driver's license or driver's operator's license, correct?
yes,
Now, it said the number on top, it's the name Michigan on top, as you've seen before in driver's licenses, correct?
yes, sir.
Okay. And it had a plastic coating, did it not, this license?
It's a uniform plastic card.
Okay, and the card itself that Mr. Jordan handed you was of the same uniform plastic coating, correct?
Yes.
And the plastic coating itself has, there's some anti-fraud, I guess, built-in technology into that card. For example, there's a black light viewable symbol on the card, isn't there?
Yes, sir. It's counterfeit, not
Counterfeit.
fraud.
This card actually had not just the name Michigan on it. It had the plastic coating. It also had the black light viewable symbols on the card, correct?
Did-
And it had a digital image on the card as well.
Yes, sir.
So it wasn't like it was taped over or it had been separately laminated or something like that, right?
No, sir.
Okay.
The point being that
It had all the elements of a,
it looked like it was a legitimate looking license, but you had some, according to your testimony, some special knowledge in terms of when it would have been issued.
Yes, sir.
well, so it appeared, it had all the elements of a, forget about the number for a second, all the physical elements of a validly issued license issued by the Secretary of State, correct?
Yes, sir.
All right. And so you take the license and you actually go back to your car, and I'm going to talk about your discussion with Mr. Jordan, but you go back to your car to run his name through Lean and or through the Secretary of State computer system, correct?
Yes, sir.
Now, as you're doing this, understand that all you possess in your hand is this driver's license, right?
Yes, sir.
You had asked him some questions about his driving record, right?
Yes, sir.
He said he had a couple of tickets in the past, true?
Yes.
You didn't ask him what specific types of tickets they were, is that true?
That is correct.
You didn't ask him where those tickets were, like in what court, for example, is that true?
That is correct.
And you didn't ask him how those tickets were disposed of, in other words, whether they resulted in conviction, dismissal, or resulted in some non-abstractable offense, correct?
That is correct.
Let's talk about how tickets can be resolved. In your experience, in your 15 years, you know that you can issue a civil infraction ticket for an individual, right?
Yes, sir.
The civil infraction ticket itself a person would have to go to court to typically contest that ticket, is that right?
Typically.
Okay, well, let's talk about the cases where they don't. It could be, for example, a waivable offense. A waivable offense is what? Like defective equipment, or could be no registration, or no proof of insurance, something like that, correct?
No proof of insurance is no longer waivable.
Okay.
But
Tell the judge what a waivable ticket is.
it's a ticket in which the defendant can take to a police authority to sign off on the ticket, mail that ticket into the court, and it gets waived or canceled.
Okay. In other words, Mr. Jordan told you that he had a ticket, right, in his past?
Yes, he did.
You did not know at that time whether it was a waivable ticket or whether it was a non-waivable ticket for which he'd have to go to court, true?
That's correct.
And can we agree that you didn't investigate that?
At that time, no, I did not.
Can we agree that you assumed the worst when you heard the word ticket, that you heard or thought that it was like speeding or something, that you assumed the worst at that point?
I don't know that I characterize it as worst, but
But you assumed that it was, you assumed something. You jumped to a conclusion about what the word ticket meant, right?
I was asking him about his record.
I understand.
So if he's...
It's pretty clear in your mind that what you weren't referring, that you didn't leave room for the option at that point that he was saying ticket could have been a waivable ticket or something of that. You didn't think that at that time. You weren't thinking that way, were you?
If you'll allow me to answer the first part of your question,
I just want to know whether you...
off for your next statement as you're doing,
Let him
counsel.
answer the
Go
question.
ahead.
All right. When I asked him about his record, I'm assuming that meant a ticket on record, meaning some type of conviction, not a ticket that was disposed of, or it wouldn't be on his record. So I asked him about his record. He said he had a couple of tickets.
You know that when I interview clients and I ask them if they have anything on their record, they always say that too, that they have had a couple of traffic tickets. Sometimes those don't show up on records. You'd agree with that, right?
Sometimes, yes.
A truthful answer, the most honest answer a person could give you about whether or not they had anything on their record, if they didn't know if it was there or not, would be to tell you they had a couple tickets in their past. Is that true? That'd be the most truthful answer, wouldn't it?
I don't know about it being the most truthful, sir. That would be speculative on my part.
Okay. The person who says to you that you go back and you run his record through the Secretary of State, correct?
I did run his record through the Secretary of State.
And it showed no tickets.
That is correct.
So at that point, you don't know whether those were waivable tickets, true?
I did not know.
You also don't know at that point whether or not those were non-abstractable tickets, is that true?
That is correct.
And a non-abstractable ticket means a ticket that someone for an offense like blockading traffic or sudden acceleration or something of that sort, correct?
Yes, sir.
So the record bears out what that means. That means that a person could actually get a ticket for speeding or something more serious, right?
That is correct.
And a prosecutor or a city attorney could agree to reduce that ticket or that offense to a non-abstractable offense, right?
That is correct.
And a non.
Okay, the reason he's impeaching the witness, this is called a questioning, and it's a line of questioning purpose to impeach the witness. And so this type of line of questioning is allowable because it's relevant to him to get to a point, okay? And it's already clear to the judge where he's going with this, you know, sometimes you'll have the judge stop the line of questions and say, hey, wait a minute. Your line of questioning is getting off the topic or off the related subject of your argument, and because they can't see where you're going with the line of questioning, and so you have to either request keep that information proprietary to you so that you don't expose your hand too early, and then the witness have an opportunity to change up what they may have answer they may have given if they didn't know what was the purpose of the line of questioning. And so in that regard, if you allow the judge enough information to know that by what means are you intending to wrap this up? But, how are you going to tie this all in? And if you are confident that you can do that, then there's ways of reassuring the judge that you intend to do so. In this case, I know and can see very well what he's getting at is he's driving home a procedural error that calls for dismissal of the case due to that procedural error. Not only is he pointing out one procedural error, but he's compounding the offense by pointing out several factors that call to order the procedural error and point out on his face that even if the witness tried to avoid a direct procedural question, he is unable to point to any other uh, statutes or codes or provisions or policies that will allow him to uh, elude his responsibility to follow protocol, because that's one of their main requirements, is that they follow protocol. Otherwise, they can be deemed as not, they're not immune. And that is the reason why the judge is allowing the line of questioning, because his the cross-examined has sufficiently broken down the immunity barrier and to allow for this type of line of questioning, because he have already proven himself uh, to have basically acted under color of law. In other words, he just pretended he had jurisdiction to do uh, what he was doing out on the beat, and he did not. And where he screwed up as uh, he messed with the wrong person who was smart enough to get or got counsel that was effective. Okay, effective. He has effective counsel, and if the uh, cops or officers out there operating out of the confines and under the jurisdiction of authority that he was given, then he's pretty much on his own. Okay? And a lawsuit against him can also ensue as a result of this, the outcome of this case. And so I don't know if he's coming to grips with that, coming to terms with accepting or understanding or seeing that uh, at this point, but it is already clear to the court. Moving right along.
Abstractable offense would mean that even though the person received the ticket, it wouldn't show up on their record.
That's correct.
I can't just maybe speed things along. I can stipulate to the fact that sometimes tickets are not abstracted. They don't. I have no objection to that.
And I appreciate that, and I think we all know that. I'm just trying to make the record bear out that when you ran his record on the Secretary of State, you concluded, you said to the judge that that was a big inconsistency in your mind, right?
I felt that that was further suspicion being an inconsistency.
Even though it could be entirely consistent with a person having had a couple of tickets, as he disclosed to you, and having no record. In other words, person receiving non-abstractable or waivable tickets, correct?
If that were the sole thing I was looking at, that would be correct.
I understand. So it really, just comparing those two facts, it isn't a blatant discrepancy. They could be entirely consistent, right? And that's all I want.
They potentially could be explained.
Okay.
To get right to the point, the facts that you had in your mind were his age, the fact that the license was only issued within, a new license at 6 months, and that it wasn't consistent with the information that he had a couple tickets in the past. Those are three bases for which you made the arrest.
No, sir, it was slightly more than that. Just to expound on your specific question, Judge, obviously the age of the defendant having a probationary original license, meaning it had just come into existence, I felt was extremely suspicious.
Okay.
Because in my experience of roughly 15,000 traffic stops, people get their license 16, 17 years old. So that was a very dramatic
Okay.
red flag.
All right.
The gentleman apparently made an inconsistency in that he said he had tickets, the record showed no tickets.
Okay.
There was no explanation for why the gentleman didn't obtain a license at an earlier age. No out-of-state record where he had been licensed in another state and transferred to Michigan.
But did you ask him any of those questions?
That showed up on my computer, sir.
Do me a favor, Trooper, answer the judge's question. Did you ask him any questions about that? The answer is no.
All right, we don't need to
Is
get, I
the
just
judge
want to know,
asking me
I want
or
to know
you,
that, you
counsel?
can cross on that.
I know.
I just want to know the basis for the arrest.
I appreciate that.
All right, what else?
On my computer screen, sir, if there is an out-of-state record, it will indicate out-of-state or it'll show a transfer from a different state.
Okay.
Also, a Department of Corrections record will show up indicating potentially that the defendant had been incarcerated to explain why there was a time lapse in obtaining that license.
Okay.
None of that information was present to explain that,
Okay.
which brings me back to the first point of the defendant's age and a probationary original license.
So those were all the factors that you took into consideration in your mind to develop a probable cause to arrest him?
Yes, sir.
Okay, go ahead.
Okay. And I'm not trying to repeat things, but the license says Michigan on it. It had the anti-counterfeit plastic coating on it, right?
Yes, it did.
It had an image where the image is supposed to be, correct? The license appeared to have been issued by the Secretary of State. I know, Judge, I'm not trying to do that. I just
You don't need to keep going over that. I understand your argument's going to be, this was a valid license on its face. There was not enough for probable cause.
Correct.
Okay.
And let me add this. You said that an important factor for the judge's in your determination or your decision-making was that the license appeared to have been issued within 6 months, correct?
To the best of my recollection, I can say newly issued, but I would have to.
Well, let's not back off from newly issued. You told the judge 6 months. It appeared as though it had been recently issued within 6 months, correct?
I believe so. I would have to refresh my memory for the exact date. This is an incident from 2 years ago.
I'm gonna try to help you do that right now so we can.
I'm surprised. I remember everything.
Well, no, I'm not suggesting that, but this license, take a look at page 13 of your report, and you want to look at it there. It's number 13 in the prosecutor's stamp. You can read the highlighted part or read any other part you want. It's entirely up to
Do me a
you.
favor, give me about a 1 minute recess.
Yes, sir.
Okay, be right back.
Wow. Wow.
Okay, just recall the case.
Recalling People versus Jordan, case number 2010-232-839, FH.
The record reflect lawyers, parties are present. Troopers can continue. Go ahead.
All right, we told the judge that an important factor in consideration was that the license had been issued, best of your recollection, within 6 months of the incident date. Do you remember that?
My recollection was that that's
understand.
correct. And I missed.
The license actually had been issued December 2nd, 2004. Is that right?
Yes, sir.
Okay. And even though it was in its first cycle of the license, you would agree that the probationary period for that license, when you stopped Mr. Jordan on May 6th of 2008, had ended. Isn't that true? Probationary period does not last 4 years, does it?
No, sir, but the license had not been renewed.
I understand that. I'm saying though that it was not in the quote probationary period. Would you agree with that?
Let me refresh myself. I don't believe you'll have the lien work in here, counsel. I may have to obtain it from the prosecutor, reference the probationary status.
It really isn't that major of a point, Judge. It's just, if he wants to dig for it and give it to us later, it's fine. My point was that the license was 4 years old as opposed to.
It had not been renewed. It was an original license. I did misspeak on the particular time frame that it had been in existence.
Okay.
Okay.
And give me 1 second if you could, Judge. Sure. And if you could share with me, Trooper, this card, you said you searched through his pockets after he was placed under arrest, is that right?
I did.
And you searched through his wallet, I believe, is that right?
Yes, sir.
And you told the judge that you found some cards or credit cards in the name of Mark Johnson, is that right?
Correct.
And you found one card that had the name Jamie Jordan on it, right?
That is correct.
And could you show us in the discovery where that card that had the name Jamie Jordan is? Did you take a photograph of it or a copy of it or preserve it in evidence?
No, sir.
Did you save that piece of evidence at all?
No, sir. I didn't feel it was evidence.
Can I have 1 second, Your Honor, if you don't mind?
Sure.
Well, why did he mention it?
Judge, at this point, I don't have any other questions to ask you.
All right, any,
Oh, I had one question, if I could, Judge.
yeah, go ahead.
Did you mention, is Trooper Millhouse mentioned anywhere in your police report as a backup officer?
I believe she is.
You take, while Mr. Polanco is talking to you, if you would, or at some point in time before we leave this hearing, look through that report and show me the spot where she's mentioned.
I'll take a look.
Okay. And if you find it, then we'll add that to the record. If not, then we'll come back on the record and tell the judge she's, okay?
That would be great.
Okay. You would agree it'd be policy to mention a backup officer in your report, correct?
No, sir.
One more.
All right, Trooper Kaiser, now, when you were at the scene,
Correct.
he volunteered that to you.
That's correct.
Thank you, Your Honor. No further questions.
Judge, may I ask a couple basic
Yeah,
questions?
go ahead.
Questions?
Go ahead.
Let me. I want to talk about this, your discussion with Mr. Jordan about his record, okay? You didn't ask him, the accused, what type of tickets he had, am I correct?
That is correct.
Okay. You didn't ask him the outcome or disposition of those tickets, am I correct?
That is correct.
You didn't ask him, and you have no recollection of asking him any specifics about those tickets, am I true? Is that true?
About those tickets?
Yes.
Correct.
Okay. So I don't want it to be out there in the open about how you went like a deer in the headlights. You asked him, do you have any, what's your record like? He had a couple tickets in the past. That's where you left him, right?
No, sir.
You didn't ask him any particulars about those tickets, is what I just established with you. Would you agree with that?
I asked him when his last ticket was.
Okay. And did
He
you?
was unable to provide an answer.
Okay, and that's all I wanted to get into. And you went back to run his name through your computer system, which you've already established, right?
Yes, sir.
When you returned to his car after having run his name, and this thing is in your head about how he said he had a couple tickets, but all your information on lien doesn't show anything, and you got all these things swirling around in your mind. Do you say to him, hey, what gives? I just ran your name through your lien and nothing comes up. Did you say that to him?
No, sir.
Did you say to him, hey, why do you have a license that's issued within the last 4 years? Could you explain that to me? Do you say that to him?
No, sir.
Do you say to him, hey, driver, I don't find any tickets, and that's a big thing that stands out in my mind. Anything like that?
I don't believe so, no.
That the Secretary of State had issued a license in this person's name to this individual at a certain address with a certain birth date, correct?
Yes, sir.
In other words, the objective information that you got from your lien run was that this man with this license and this name was allowed to drive in the state of Michigan on this date, correct?
That's what a fraudulent retained license
Hold on, I
is.
didn't ask you that. I just want you to answer my question. I know what you want to tell Mr. Polanco. Just answer mine, okay? The actual Secretary of State lien run that you showed was that he was lawfully allowed to drive, correct?
Under that identity, yes.
Okay. And once you ran all this stuff on the computer, you returned to the police car, or to his, to the Mr. Jordan's car, and you engaged him in no colloquy, no discussion. Isn't that right?
Essentially, that's correct.
You didn't ask him any questions about any of that.
That is
You
correct.
just arrested him.
That's correct.
So the entire investigation arrest sequence lasted approximately 4 to 5 minutes, true?
Ballpark.
And it's at that point that Mr. Jordan was removed from the car. You began your
What kind of investigation?
arrest or detention procedure, correct?
Correct.
Would you agree with me that at that point, Mr. Jordan was not free to leave, that he was being detained by you?
That's why he was in handcuffs.
Okay. What you just said about how long it took and what you gave Mr. Jordan, that's not entirely true, is it, Trooper Hester?
I don't understand your question.
Well, when you returned to Mr. Jordan's car from having done your lien run, you actually started to, you swore at him, didn't you?
No, sir.
Didn't you say to him, who the F are you?
No, sir.
Didn't you press him about what he was doing and you wanted to get to the bottom of it and you were going to? Didn't you do that?
Yeah, I think it was outside the scope of my redirect. This is basically what we're cross.
You know what?
There's,
It may be true. I have discretion. I want to get, let's get all the facts out. This is really the whole key to this situation, okay?
Yeah.
isn't it a fact that you actually continued to press Mr. Jordan about details and whatnot for approximately 45 minutes from the time that you stopped him until you actually made the decision to arrest him and to call for a tow? Isn't that true?
Absolutely not.
You called for a tow, would you not agree? And I mean a tow, like your decision to impound his car, you did do that, didn't you?
Yes, sir.
And you made the decision that there was no one there to take over his vehicle once you arrested him, correct?
I would have stood by for the tow truck, but
I understand.
Trooper Millhouse arrived.
Okay. Have you looked at the report, by the way, to answer the question I asked before about Trooper Millhouse?
No, you've been kind of long-winded, Counsel. I haven't had an opportunity. Give me a moment.
Sure. You can berate me, and it's okay by me. I have no problem.
No one's ever said that about you.
No, they haven't. Well, it won't be the first time. I also have, won't be the last. Won't be the last time that this won't be the last time that I've also cross-examined a police officer who has wit and charm.
That's a compliment, Trooper.
Thank you.
Not for me, from him. Don't thank him. All right.
It's out to get blessings, Lord. Oh, wow, he's taking up all the time. Bless his Lord. He'll find it.
I don't see that recorded in the documents you've provided me, Counsel.
Well, I don't want the record to suggest that there's something else that I haven't given you. Is
Okay.
there something else that has her name on it that you have made part of your official report? What's that? Nothing that I've ever gotten in this case. We had to track her down like the Dickens. We had to actually pay someone to go and try to track her down. We never.
Wow. 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 This case is falling apart. Thank you.
Get some water.
Yeah, please, Your Honor. That'd be great. Thank you.
Give him a
Mr. Blunt looking for the document.
Oh, wow. Like
Like
he's
kind of officer.
that hand movement. I'm done.
I anticipate forthcoming concession.
Oh, bless
If it doesn't, but it's not there.
his
Spoke about the different trooper, sorry.
heart. Bless his heart. He needs to be hydrated
You
now.
completely omitted her from your report, isn't that true?
Structurally, yes, sir.
I have no clue what that means structurally. Do you mean that you didn't mention
He
that
said he
that
structurally
Burnett
removed
Millhouse actually played an official role in this case in some capacity or other? Is that what you mean by that?
She played no part in the arrest sequence and criminal proceeding of this case.
I just want to know whether or not, you said structurally. Do you mean that in the entire body of this police report that you did not reference Trooper Millhouse having played any role?
She should be listed on the vehicle form, but I'm not seeing it in the stack of documents you gave me.
Is there some definition? I want to be clear that I've given you a packet that contains an investigation that spanned what looks like a couple of years.
Yes, sir. I don't see the document in there.
Wow.
Trooper Millhouse, you didn't even reference that you even had a back officer that day, isn't that true?
I'm sure I mentioned it in our prior court proceedings, but I don't get in our report, sir.
I know. This was our question about it. I'm talking about, you know that I'm talking about what you wrote in your report, not what you're answering to my question. I just want to know, would you concur that her, on that or Mr. Blanca, would you concur that she's omitted it entirely from your report?
As I've stated, I don't see her memorialized in the report.
And if you arrested Mr. Jordan within 4 minutes or 5 minutes of your having stopped him, which is what you testified to, you didn't call for backup or for a tow operator to come do anything with his car until what looks like about 10:30 or so. Do you dispute that?
No, I wouldn't dispute that.
So you actually had this man alone at the scene with just you. You're saying he's been under arrest for about 45 minutes or so. What time? Is that right?
Including the time I stopped him, our conversation, computer checks, searching the vehicle prior to impounding it, and requesting, that was probably about 40 minutes.
Well, the policy, actually, the state police policy about searching the vehicle pursuant to impound is that you actually have to have the impound operator actually sign off on the contents of the vehicle. Is that true?
Yes, sir.
Okay. Well, you just said you searched the vehicle before you even called for impound.
That's right.
So you did the search without even having the person who's going to take the car actually even look through the contents to verify that what you say you found is what you found. True? Is that true?
Please rephrase that.
You say that during the 45 minutes that you searched through this car, that you did it without the impound or tow operator even being there.
That's correct.
So you couldn't have followed the state police policy which says that you're supposed to have the tow operator actually observe what it is that you found during the search of the car so that the accused belongings can be properly chronicled. Correct?
That is incorrect.
Okay, so you have Mr. Jordan, you said, and during that 40 minutes or so, from the time that he was arrested until the time that you called for this tow company to come,
Can we stop this?
you say you didn't ask him any questions at all. You didn't berate him, you didn't press him about who he was.
I was busy searching the car. Upon arrest, he was inquiring to me what this was all about, and I told him I did not believe the identity he provided was true, and I placed him in my patrol car.
And where is that in your police report? Where is that colloquy in your report, Trooper? Where's any of that? Go ahead, you got the whole report there. Look through it. Find the spot where you said that he questioned you about that and you engaged in that colloquy.
Sir, it wasn't a question to him, nor a response to one of my questions, so I
understand,
didn't.
but you didn't,
put that
this is a statement by an accused. You're claiming he made a statement to at the scene. Where is that statement reference in your report? Would you agree that it's not?
Absolutely, it is not.
Define me that it's not. You know it's not.
Correct.
So you have an accused that's asking you questions about reasons why he's being stopped, and you just omit that entirely.
You can ask it 10 different times, counsel. The answer is going to be
Okay.
no.
Wait for a question.
He doing the most.
Now, you testified that as you were in this discussion with Mr. Jordan, where you had going through the belongings in his wallet and whatnot, and you hold up this Sam's Club card, that you say that took place in your patrol car.
Correct?
I thought we're limiting this
We are.
to the basis for the arrest.
I did too, Your Honor.
Yeah, okay.
Wow,
He
he
annoys me
asked for
sometimes,
mercy. Bless his
He must
soul.
get paid by the word, Your Honor.
You know what's interesting is I thought the same thing about you, Trooper
No, it's
Geiser.
enough.
I thought you got paid by
Let
the
him,
word.
let's just, call it quits. Okay. It's enough.
Would you just, and I'm just going to hand you what we've previously marked as Defendant's Exhibit E, just to corroborate what I said about the tow records and when the tow truck was called. Have you seen those before?
No, sir.
Is that the tow company you called?
It appears to be.
Is that the tow company that responded?
I have no independent knowledge of their records or process keeping, so it's paperwork with their name on it. It's all I can tell you.
Okay. I don't know, Judge, I'm going to move for its admission under 104B. I don't know if Mr. Palumbo has an objection. Otherwise, we've attempted,
What's the relevance?
it's just to show how long when the trooper actually called for a record, it shows 10:30. I don't know.
Yeah, but it's, again, it's.
I understand.
Maybe, credibility or whatever it is, but we're really down to, you've got a traffic stop. You've got, you're not going to argue that you shouldn't ask for a license. He gets a license. It appears to be a valid license. He's got suspicions because of the age and his special knowledge of when it would have been, that would have been the first license issued to that person. He went to the car, ran a lien. He didn't see that he was, just got out of jail or prison or anything from another state. And that when he asked him, have you had any prior, traffic, he said he had a couple tickets, but couldn't say when. That's basically all the facts that you have to determine what or what didn't happen.
I understand.
In other words, from a legal standpoint.
I don't have
And I really have no idea whether at the moment that's enough for probable cause. Any other questions?
No.
All right, thanks, Dr. You're all set.
Thank you, Your Honor.
Make these exhibits back.
He
Give us
already
Mr. Blanco.
established, don't beat him up.
All right, do you have any other witnesses?
The judge said it
Could you give me about 5 minutes to
twice.
talk to my client,
Okay.
just to kind of make it
Okay,
sound.
sure. I'll be in recess. Yeah,
Thank you.
no problem.
Stop the bleeding. They had to stop the bleeding. Bless his soul. Bless his soul. Y'all, thank you for watching.